What's the best offshore trust jurisdiction? We'll do a comparison of asset protection trusts around the world. Many experts consider an offshore asset protection trust as the strongest asset protection vehicle on the planet when established in the proper jurisdiction. First, you, as the trust settler, designate the trustee and the trust beneficiaries. Next, you, as the trust settler, convey the assets to the trust. Now, notably, only a few jurisdictions have laws that strongly favor the offshore asset protection trusts, and these jurisdictions are the Cook Islands, Nevis, and Belize. Unfortunately, all three of these jurisdictions have laws that provide very strong asset protection and are very politically stable. Furthermore, many legal experts agree that the Cook Islands has the strongest asset protection case law history. And by the way, if you want to see more videos like this, subscribe if you haven't already. Now, with an offshore trust, if you would like, you can name yourself as the only beneficiary to the trust. Alternatively, you can have several beneficiaries. For example, you and your spouse, and when you and your spouse both die, the beneficiaries become your kids. The government does a thorough background check before they license a trustee. In addition, the offshore government regularly audits the trustees. Don't like your trustee? No problem. Just fire them and hire another. Now, you can remain in control of your investments. You can log in and see your money online. You can do stock trades and so on. Or you can legally require the trustee to take your direction on investments. Okay, now let's go ahead and take a look at a chart comparing the different jurisdictions. Here we have Bahamas, Belize, Bermuda, Cayman Islands, Cook Islands, Gibraltar, Jersey, and Turks and Caicos. Now you'll quickly notice that the row under the Cook Islands is highlighted, and there's a reason for that. In the Cook Islands, the settlor, that's you if you contact us to have us set up the trust, can also be a beneficiary. So you don't lose beneficial interest in the assets such as your bank account and your investments that you put into the trust. Retention of control by the settler. You can retain some control over the trust and still have asset protection. You have protection from subsequent bankruptcy. So even if you file bankruptcy, your assets are still protected. Protection of the beneficiary. So we can add protection for both you as a beneficiary, and when your children inherit the money, they can be protected as well from divorce, for example. Avoidance of forced heirship rules. That means that you can have the people inherit the money who you want instead of what is dictated by law. Protection from foreign judgments. Specific non-recognition provisions. That means that Cook Islands does not recognize foreign court judgments and court orders. One would have to bring a whole new case in the Cook Islands, which is very unfriendly to creditors going after your money. The Hague Convention is not applicable, so provisions that may leave your assets vulnerable under the Hague Convention are done away with. Protection from creditors. Exclusion from the Statute of Elizabeth laws. And what that means is, for example, the Statute of Elizabeth says that a trust can only last so long, whereas a Cook Islands trust, it can last indefinitely. It can take care of future generations. Now, fraudulent conveyance is a legal term. It's not like fraud, like tricking people out of their money, but fraudulent conveyance means keeping money away from creditors. So even if it was found that you set up the trust to keep the money away from creditors, your assets can still be protected. To try to prove that you fraudulently conveyed the assets into the trust, that burden is on the creditor. There's a clear definition of fraudulent transfer. There's a separation of creditor claims. That is, if one creditor has a judgment against you, that's a totally separate issue from another creditor. And the statute of limitations is as short as 1 year. When somebody says, hey, you fraudulently conveyed the assets into the trust, after a year, your opponent doesn't even have the right to challenge that transfer into the trust. And in the unlikely event they brought a case in the Cook Islands before that time, your assets are still protected and they still have a huge legal hurdle to climb over before they can get your assets. In fact, our organization has established more Cook Islands trusts than anybody in the world. We've never seen one of our clients get a legal attack in the Cook Islands itself because they can see that if they try, there's really little to no chance of somebody spending a bunch of money and getting assets out of the trust. Retroactive protection for immigrant trusts. What that means is, let's say you set up that trust 3, 4, 5 years ago, the statute of limitations will have already expired. By the time it becomes a Cook Islands trust, your opponent won't even have a chance to try to file a challenge in the Cook Islands. Community property provisions. That means even if you live in a community property state, your assets are still protected from a divorce. Specific exclusion for foreign law. What that means is the Cook Islands law is the only law that applies in the Cook Islands. Foreign rulings, foreign judgments, they get ignored. Choice of law is binding, so only the Cook Islands law applies. And they'll also allow you to have a custodian trustee if you'd like to have them manage assets, like a money manager, for example. So you can see of all the trust jurisdictions, Cook Islands has the most advantages. Also, if we were to add the Nevis trust to this chart, it would be similar to the Cook Islands because basically Nevis copied Cook Islands trust law. Another favorite jurisdiction of ours is Belize. You can see the statute of limitations here. This gives it an advantage of 0. So once the assets are in the trust, the statute of limitations has already expired, and you don't have that little window of time to be able to challenge that transfer. Even in the Cook Islands, the assets are protected right away. They have a little window of time to challenge the transfer, but we've never seen any of our clients lose money they have had in one of our Cook Islands trusts because the legal barrier is so high. Now, as a quick illustration for how the trust works, you have your offshore trust. Inside, we put an offshore LLC, which we'll talk about in a little bit. The trust company law firm is the trustee of the trust. You are the manager of the LLC and the initial signatory on the bank account. The beneficiaries, such as you and your spouse, and when you die, your children can become beneficiaries. You have an optional protector provision that can oversee the trustee if you want to have that. Most people don't have it. And we can protect domestic assets with LLCs, liens, equity stripping, and so on. When the bad thing happens, our trustee law firm can step in as manager of the LLC. And when the judge says, give me the money, our trustee law firm says, hey, we don't have to comply. You don't have jurisdiction here, and your assets are protected. Okay, so the advantages of an offshore trust. The major advantage of an offshore trust is asset protection. Thus, it keeps the assets out of reach of creditors. Moreover, U.S. judges, and those in other locations, the UK, Australia, so on, do not have jurisdiction over foreign citizens, and as a result, local judges cannot legally compel the foreign trustee to release the funds to your judgment creditor. The Cook Islands, Nevis, and Belize trust jurisdictions do not recognize judgments that originate from a foreign country, such as the U.S., and your legal opponent has to start a new lawsuit in that jurisdiction, which you're probably going to lose. So some offshore jurisdictions place many obstacles for those who attempt to bring any litigation to the trust. In Nevis, for example, a creditor must post a $100,000 cash deposit with the courts before they can even bring suit against a Nevis trust. In the Cook Islands, the creditor must prove beyond any reasonable doubt that the settlor transferred the assets into the trust in order to defraud that particular creditor that's bringing the case. So again, what's the best offshore trust jurisdiction? One reason why the Cook Islands Trust is one of the best offshore jurisdictions and why we've set up more trusts there than anybody in the world is its short statute of limitations on fraudulent conveyance. It states that the time limit for your opponent to claim fraudulent transfer is 1 year from the date the lawsuit started or 2 years after the underlying cause of action. So when the lawsuit is completed in the U.S., the statute of limitations in the offshore jurisdiction will usually have expired. Therefore, your creditor could no longer successfully pursue the lawsuit in the Cook Islands at all after that time. And as a result, there are exceedingly few trust lawsuits that creditors pursue in the Cook Islands. And moreover, if your opposition brings the lawsuit before the clock runs out, the opponent must prove that sole intent for creating the trust was to defraud that particular creditor. To top it off, like we said, the proof must be beyond the shadow of a reasonable doubt, a very high legal hurdle. So whereas it is best to place funds inside before legal challenges, this is one rare legal tool that has consistently displayed its asset protection effectiveness after the fact. Okay, so the best offshore trust jurisdiction strategies. One of the best asset protection strategies combines an offshore LLC and an offshore trust, such as one of the Cook Islands. So you can hold assets such as your offshore bank account here inside of the offshore trust. The foreign trust holds all of the membership interest, that is the ownership of the LLC, and a U.S. resident such as you having the trust created can be the manager of the LLC. The manager has all of the legal control over the LLC and the signatory on the bank account. And then when properly structured and properly operated, it effectively protects the creditor from running off with them. So it is possible in this case for a U.S. resident to control all of the assets, to have full access to them, and yet, quote, own none of them because they're in the trust. So that's what protects the assets from the court. And when the bad thing happens, you temporarily have the licensed bonded trustee law firm step in as manager here of the LLC and manage your accounts. So now the trustee will do what you paid for, protect your assets. That way, the only time the trustee steps in on your behalf is when the courts would take the money. When the bad thing goes away, the trustee restores you as the manager of the LLC. Now, every once in a while, we'll get a question, and they ask if the court can hold them in contempt if they do not bring back the funds they've placed offshore? And the answer is, if a professional has properly drafted the trust, the law protects those who have placed the funds in the trust. And the protection from the creditors arises from what we call the duress clause. If the trustee determines that your request for funds arises from a court-ordered duress, the trustee is duty-bound under the terms of the trust to step in and protect your assets. So if you say, turn over the assets because the judge told me to, you're complying with the judge's orders, but the trustee is not going to comply because you're not doing it under your free will. So let's say a judge orders you to bring back the funds. So you write a letter to the trustee letting them know that the court has ordered you to repatriate the funds and make them available to your judgment creditor. The trustee, in turn, responds that he senses that you wrote the letter under duress, so he will not release the money in practice, or the trust company, the law firm. So in practice, what you do is you call us and you tell us your predicament, and then we pass the news along to our Cook Islands law firm that serves as the trustee. So what do you tell the judge? On your appointed day, you return to court and you inform the judge what transpired. You say that you told the trustee to bring the funds back, the trustee didn't bring the funds back, and let's say by some stretch of the imagination, the judge, visibly displeased, declares his intent to hold you in contempt. So calmly you respond, hold a minute, judge, or your attorney will more likely do this. Your Honor, to hold me in contempt, 3 prima facie elements must be satisfied. First, there must be a lawful order. Certainly there was one. Secondly, it must be known to the contemptor. Indeed, I was standing right here when you issued it and I speak English. Finally, it must have been willfully violated. I did not violate your order. To the contrary, I ordered the trustee to bring back the funds. I demanded they did it, but they didn't comply. Therefore, I did not willfully violate your order. It is simply impossible for me to comply. So you follow the same reasoning if the judge attempts to compel you to revoke the trust or dissolve the trust. You can't do it personally without the trustee's cooperation. So domestic law protects you from the contempt, while the Cook Islands law protects your money. Okay, let's talk about offshore banking. The offshore trust is best suited for holding offshore bank and brokerage accounts. And as of the most recent report from Global Finance, of the 50 safest banks in the world, only one is located in the U.S., and it's not a major bank. It's a teeny tiny farming bank. There's only one, and it's on the bottom half of the list. I think it's number 37 out of 50. So there are much safer banks located outside the U.S. than inside. And on another note, U.S. courts have jurisdiction over banks anyway, so you wouldn't want your bank account to be in the U.S. U.S. courts have jurisdiction over U.S. real estate. So domestic courts can demand seizure of such assets, whereas you can hold title of domestic real estate in the LLC that's inside the trust, but you should really either liquidate the real estate and move the cash offshore in the event of legal duress. So you want to keep the assets out of the reach of the courts. So what else can you do for real estate asset protection or assets that you really can't move? How do we protect U.S. real estate, for example? We do this through equity stripping. That is, we record an equity line of credit, mortgage, or deed of trust on the real estate. Then when needed, we have an offshore finance company acquire that mortgage. And then the loan proceeds are placed inside of your offshore trust. Now, it would be too risky for the lender to let you run off with the cash secured by some foreign real estate. So the funds are placed in the account. They're in a you can't touch it account, so you can't run off with the money. That'd be too risky. But what it does, it shows to the judge that you have the proceeds from the mortgage and that a true third-party lender has acquired. So let's talk about asset protection and safety. Now, the trustee is a licensed bonded law firm, meaning they went through intensive background checks before the government granted them the license. The trustee is bonded, meaning that the funds the trustee manages are insured. Moreover, the trustee company that we utilize has been in the business for over 30 years. And again, with most asset protection trusts, the only event in which the trustee really needs to step in on your behalf is when the courts would threaten to take your funds anyway. So the two main alternatives in such an event are as follows: 100% chance of the courts taking your funds versus protecting your money in a trust by a licensed bonded trustee that has faithfully protected clients' assets for over 30 years. I've been setting up Cook Islands Trust for just about 30 years, and I've never seen anything happen that I would say isn't above board, honorable, and in the client's best interest. I mean, if it did, the Cook Islands trustee industry would be shot if it even happened one time. So that's why we really rely on the Cook Islands trustees. I have a Cook Islands trust for myself and my family. So call us for more information to establish a Cook Islands trust, a Cook Islands LLC inside the trust, the offshore bank account, and we're glad to help you. Subscribe if you haven't already, and we'll see you in the next video. This is The Business Guy.